Yeah, my friend Sam Gituku is asking a very fundamental question. Could this also have been as a result of the Chief Justice's negotiation skills? There's a soundbite during her vetting that she said something about her negotiation skills. Here it is.
What do you think you will do that will make sure those judges are sworn?
It is of utmost urgency that these 40 judges are sworn in office. So I will negotiate because, like I said, I have very good negotiation skills. If there are problems with some, that problem can also be sorted out, because if you have a problem as a judge, it must be sorted out one way or the other.
Sorted out in one way or another. Let's wait for the sorting out.
Was it subject to negotiation?
It ought not to be.
Yeah.
The only document that should guide relationships even between the state organs, the three arms of government, is the Constitution. And it's written in a way that actually guides how they should relate. Here is what is tricky for the new Chief Justice, who has just done a week and 4 days in office now. She is going, Chief Justice Martha Koome will be judged very, very harshly on how she handles the defending bit of the judiciary. And the other thing is, and Jamila, you spoke of perceptions earlier. Perceptions are dangerous. And if there is one person in the whole scheme of things that must run away from ugly perceptions, it is the new Chief Justice. It should not be, actually, she should not feel it's a good thing to be seen to be associated with the executive, because that association might be seen as compromise in terms of compromising on the independence of the judiciary. And you know, Kenyans do know that the Constitution of Kenya 2010 departed very, very strongly from how we used to do things and gave the judiciary its independence.
Interesting.
Wow.
So
anyway,
allow me to read
we can segue into Kisumu, because I think the president spoke a lot about the judiciary there as well.
Interesting. I was seeing two tweets, one by Martha Karua, that cherry picking of JSC appointees may amount to deliberate intimidation of Kenya judiciary, especially in view of the uncalled for attacks of the institution by the president in Kisumu, coupled with the pending BBI appeal. We must stand firm. Then there's a gentleman called Erickson Nyamoya. He's saying the basic structure doctrine also applies to appointment of judges. If the president has a constitutional duty to protect and uphold the Constitution, then in all honesty, if a judge has Chapter 6 questions, the same president cannot close his eyes. And the debate goes on.
Okay, maybe we can listen to the president talking about the judiciary in Kisumu. Talking about the judiciary testing the limits. I think that's what he said.
Yep.
As a consequence of 2017, we initiated, together with millions of Kenyans, the BBI process that was meant to build bridges and create inclusive politics and end ethnic majoritarianism. If the court had subjected its decision to stop BBI to a cost-benefit analysis, in other words, if it had considered the burden of choice, from the nullification of a presidential election in 2017 to an attempt to stop the will of the people as expressed through the BBI, the judiciary has indeed tested our constitutional limits.
Wow. That was, I would say, loaded.
Very loaded.
Who will go first?
Yvonne.
So it was loaded not just about the judiciary, but there was also, he mentioned independent institutions. And I think that could go, much further than just the judiciary, where he says, but this balance is probably most challenged by the growth of our independent institutions, and that growth has stretched our democratic boundaries to the limit, but not cracked them. Now, from this, it's obvious that he's still smarting from the 2017 ruling that nullified his election. And it seems to me to be relitigating an issue that was already settled by the Supreme Court. That matter was heard, finished, determined, and the outcome of that was decided. In fact, there was a repeat presidential election, which he himself participated in. So to talk about the nullification of the 2017 election as an attempt to stop the will of the people, and for him to also talk about the fact that BBI, we're speaking in terms of guarantees, that the BBI is what will stop strife in the country, I think is what I found interesting. But there was one thing I'd wanted to just fact check, and I don't know if we have it, but this is what he said, in giving defense to the BBI, and he said, and I quote, that we lost 1 trillion shillings in only 123 days, all for naught. And this is the 123 days from the first election, the nullification, and the repeat process. And then he went on to say we were losing 1 billion every working hour for the 123 days we held the 2017 election. Now, it's important for us to fact check this, because this is what he's using as a basis for the BBI process and the changes therein. If you were to do the math with this, so let's take losing 1 billion every working hour. So that's what, 8 hours in a day? That would be 8 billion shillings per day. Over the 123 days, that's about 984 million shillings. That's approximately 1 trillion. Now, 1 trillion. 1 trillion, yes. And if you take a look at the KRA revenue collection for the year of 2017, it was about 1.5 trillion. So something doesn't quite tally. That we lost almost 1 trillion in 123 days when the KRA revenue was about 1.5 trillion, or rather 1.3 trillion, excuse me, in that year. Also, data that comes in from the KRA itself, in fact, shows that period when we had this 123 days, that in fact our revenue collection was much higher that quarter 2 than quarter 1. So somewhere these numbers are not adding up, and it is important to fact check this, because this is what he's using as a justification for the handshake, the BBI process, and therefore the subsequent attempts to change the constitution. And I just think it's important, for facts to be stated correctly, particularly when you use them as a basis for that argument. And so that's what I wanted to just make clarity on.
And I think we will talk in a lot more detail about BBI in a moment. I don't know, Linus, this whole, because I have not seen him talk like that about the judiciary since actually 2017. There have been statements here and there, but those were extremely strong statements coming from the president about the judiciary on the back of a very consequential ruling whose appeal is just getting underway. And actually the president is one of the appellants in this BBI case, to the extent, of course, that he was very personally singled out by those judges in that decision they made.
Yeah, he spoke with a lot of anger and directness in a way that unfortunately makes it really awkward for the new Chief Justice, Martha Koome, who sat there listening to the tirade against the judiciary.
In her first public outing as Chief Justice.
Yeah, as Chief Justice. She has had the worst start ever for any Chief Justice. Very, very awkward. You get appointed with this perception that you have a friendly executive, but then on the first day of your outing, basically with the other arms of government, there's this very, very angry attack on the judiciary. So that was rather awkward. There's something else that he does, and a lot of people have been saying this, whether in social media or analysts. It reinforces the perception that the president wants to impose his hand on decisions of the court, especially with regard to the BBI court case. it came almost as a direction. We are watching you. It's a finger-wagging kind of thing. And back to the issue of the 2017 presidential election, nullification of presidential election results. It comes out very clearly where the president's, the epicenter of the president's anger with the judiciary. It is about the decision of September 1st, 2017. And we all remember when he was in that drive about in Eastlands, saying that we shall revisit. And calling the judges Wakora and all that. That anger has been residing in the president's chest, and you can tell. Because somehow, for the first time, it found its way to the official speech of Madaraka Day. That was big, that you are going to say the decision of 2017 was wrong, costly, and all that. But here is something else that ought to be observed, and that is the silence of the beneficiary of the decision of 2017 nullification of presidential election results, Raila Odinga.
He was seated right there.
He was seated right
there.
That
statement was made, yeah.
Yes, so where do they stand tonight? James Orengo is the, well, President Kenyatta says is
the best lawyer
the best lawyer is going to defend the BBI case. Here is a very awkward situation for all these players, where James Orengo may even have to find himself disagreeing with the 2017 election for handshake's sake, for politics' sake. We are in an awkward space. But we must
played a key role in actually bringing about that decision that the president is so unhappy about.
Absolutely. But let's look at it very broadly. They said BBI is about fixing the ills that afflict the country. And one notable issue that this country has had since 2007 is elections. Every election, basically from 2007 to 2017, has been a bloody election. Contested, you know, there's violence, there's death. And strangely, in the last election, we had the death of an election official. The IT manager, Chris Msando, was killed, and we do not know to date what killed Chris Msando. Then there is a decision now that the president is trashing, a decision that tells us, blow by blow, how IEBC failed to follow the process in carrying out a presidential election. But what is happening, both the president and his handshake partner are going to put that under the carpet, sweep it under the carpet literally, and say no problem with that. We need to discuss BBI, and BBI has nothing to do or little to do with elections, and has zero to do. And there are no lessons absolutely borrowed from what the Supreme Court did in 2017. I think we are missing an opportunity to heal the country, especially to fix the questions around elections, processes, tallying processes. Because when you look at what the court did in 2017, they asked very basic questions. Why do we have more people voting for president than voting for other offices? Where do you take these other ballot papers when you put the presidential one in the ballot box? I think in the totality of things, the president, as he continues to trash the 2017 Supreme Court decision, and the former Prime Minister Raila Odinga, as he continues to keep silent and never talking about the 2017 Supreme Court decision, we are missing an opportunity to fix what I actually believe it to be the problem number one that we have as a country: elections.
And I think one of the things that, for me, I think what I find particularly worrying. I mean, obviously, anybody, any Kenyan, can have an opinion about decisions rendered by any of the state organs, the judiciary, parliament, and all of that. But I think there is a difference, a major difference, when the president speaks about it, and especially in the terms that he did, in the sense that the courts are sort of the last line of defense, as it were, when you talk about a society that is governed by the rule of law. In the sense that if all of us around this table today disagree about something so fundamental, we would actually go before a court, and then they will say, you know what, you are wrong, you are right, this is how it will go, and we all abide by that. That is how we chose as a country to govern ourselves with that 2010 constitution. Secondly, if you think about the role of the judiciary, then my mind must go back to 2007, 2008. The chief reason that was given by the people who did not go to court and resorted to street protests and all these things was because they said they didn't have confidence in the judiciary. Right. They didn't believe that the judiciary was independent enough to render a fair judgment. And the moment that certain statements are made, starting from even that time when there were all those parliamentarians, and we spoke about it, who wanted to censure judges based on what they had done and what the decisions they had given. That kind of thing is dangerous to the extent that it chips away at the independence of the judiciary, and more importantly, it delegitimizes the institution in the eyes of the public. Because then, if somebody tomorrow says, "I don't believe in those courts, they have stretched the limits of our constitution," they are doing all kinds of things, and people can do that because people listen to the politicians. The president is a powerful politician; he has a big following. So there's a sense in which a certain degree of restraint is important when you're talking about people who hold those kinds of office saying certain things about institutions, very, very young institutions insofar as constitutionalism goes in this country. These are institutions in their present form that are basically just as old as the 2010 Constitution. As a matter of fact, you could even say they're younger than the Constitution because they came after the new Constitution was promulgated. So for me, I think that is a major point of concern, that as we go through all of these things, those who hold positions of that nature need to think about that, because we lose the judiciary.
Yeah, I wanted to ask a question. Sorry, just a quick one. On when he talks about, the courts bending, the constitutionalism and subverting the will of the people, as it were, with respect to the BBI. And my question is, where are the people? We were told that 4 million people, signed up to the BBI petition. IEBC verified 4 million signatures. If indeed the courts had ruled against what the president is saying is the will of the people, surely, where are these 4 million people, and how come we have not seen them express their displeasure with the court's ruling? So far, we've heard from the politicians and the proponents of the BBI. In this country, we know all too well, when Kenyans are not happy with something, when they are displeased, when they need their voices heard, they will have their voices heard. We've seen Machozi Mondays, in fact, go back to 1991, 1992, when Kenyans, at the time, maybe people would say, there was a constitutional moment, there was a clamor for multipartyism, there was all sorts of people who are not necessarily leaders even in the executive, but who are pushing for change. But my question is, if this indeed was something that so aggrieved the will of the people who really wanted the BBI to go forward, we surely would have heard from these people by now. All of the press conferences we've heard are from people who are proponents of it, and particularly the leadership. But in this country, surely there would be people on the streets. Where are they? Where are these 4 million people? And why aren't we hearing from them to say, hey, I signed up to that BBI bill, that draft, and I am unhappy with the courts because I believe they're saying, or their verdict or judgment does not reflect my will as a citizen of the country. And that for me is something interesting.
Yvonne, we've spoken here about people even knowing the content of the BBI bill itself, or the report, or what is contained in it. Because what people know about it, or the information they may have about it, is what they hear probably from politicians about the 70 constituencies, about the office of the Judiciary Ombudsman, about the creation of the office of the Prime Minister and the Deputy Prime Ministers. But there's so much more in that document, but people don't know about, because I believe that people have not seen it. We keep talking about how it needs to be translated, people need to be holding even public barazas, people need to be educated about what's in the document. That's one. Number two, when the judges were making the ruling, the 5 judges make a ruling based on evidence. And it was unanimous. It was all 5 of them. What was presented before them, it is what they ruled on. What arguments were presented before them by the lawyers is what they ruled on. There are those in the legal circles who may say that the AG should have presented a stronger case, should have taken that case before the High Court more seriously. Because, as I said, what the judges ruled on was what they had seen, what they had, and they made those in 18 points. But then now, as you talked about how the judiciary is where people run to kupata haki. The judiciary ni kama custodian wa sheria, kuhakikisha kwamba sheria zinafuatwa. And then it's its function, it's supposed to constrain power, the judiciary. Yeah. But then now when the president in his office, because when he speaks at the podium on Madaraka Day, he's speaking as the president of the Republic of Kenya, not as an individual. When he speaks like that about them, it sort of like makes the institution look weak in the eyes of the people. It clearly shows that this is an office that probably does not have much respect for. And as you said, you run to the courts kutafuta haki. But then now you see this and you're thinking, maybe this institution is not what it seems to be or what it is supposed to be. So you talked about how important it is. Those perceptions, again, are very important about what you say and the finger pointing and the reasons given behind it.
Joe, I look at it this way. There's the place of an independent, impartial, and responsible judiciary. There's no doubt about it. An independent working judiciary is good for everybody. It's good for all of us. A judiciary where any litigant, big or small, government or an individual, knows that if I go here, I will find justice. And not just find justice, but even the process of seeking that justice will be clear. Whether you win or lose, you will see somewhat justice has been done. So there's a question of an independent judiciary. There's no doubt about whether people can question judgments that have been made or decisions that have been made by the judges. Sometimes the government will feel aggrieved. Sometimes the government will celebrate some court orders. Because, look, we've seen demolitions in this country as a result of court orders. We've seen people who have, let's say, inhabited areas where roads are supposed to be constructed, or pipelines, or anything else. And using a court order, the government has gone on to demolish houses and evict people from such areas. Those are court orders that have been respected. But at the same time, the government has also been taken to court and has lost in some cases. So it shouldn't be a good judiciary when you win and a bad judiciary when you lose. It should be a judiciary whose judgments and decisions are respected. You have every right to question decisions that are made, and even particularly for the BBI matter. That's why we have a Court of Appeal and a Supreme Court. So if you're dissatisfied with the High Court judges and the verdict they rendered, that's why there's a Court of Appeal. Proceed there and question the wisdom, the process, and the interpretation of the law by the 5 judges. But don't abuse them, don't call them names, question their wisdom in a higher court. And at the same time, it is also important to point out at this point that if you look at the relationship between the executive and parliament currently, I mean, you can clearly see that parliament is not the parliament that was envisaged by this constitution. More often than not, you'll see parliament will make decisions or, pass bills without so much inhibition on what the executive wants. Actually, put it this way, the executive gets what it wants in parliament. And some of the laws that have been passed by parliament have been annulled by the courts. So I think it is important to keep saying we need to have a very independent judiciary. But at the same time, not forget that with that independence also comes responsibility. So the place of an independent judiciary. Which is why we have JSC.
JSC was meant to make sure that any judge who runs rogue is actually reined in, is actually even kicked out of office.
Precisely. So once in a while you'll see critics of an independent judiciary say, but why are you not talking about responsibility? They go hand in hand, but that responsibility cannot be by shouting at the judges. It is by following the law. If a judge has gone rogue, then use the legal
and the custodian of that is
to take them back to line.
But I really want us to talk about BBI and the appeal process briefly before we go. But Linus, you can.
Yes, Joe, I just wanted us to listen to a few more sound bites from Kisumu. And Robert will help us through this by listening to the president talking of the burden of choice. And we also had the deputy president making his own very long submission on constitutionalism. Let's listen to those 2 bites and proceed.
consequence of 2017, we initiated, together with millions of Kenyans, the BBI process that was meant to build bridges and create inclusive politics and end ethnic majoritarianism. If the court had subjected its decision to stop BBI to a cost-benefit analysis, in other words, if it had considered the burden of choice, then there are questions the judiciary would have asked. If we indeed were at a constitutional moment, is a decision against BBI a decision in support of the status quo? If BBI were to be stopped, who carries the burden of choice? On whose shoulders will ethnic majoritarianism rest? And who will carry the burden of losing 30% of our national budget every 5 years due to the toxic politics that BBI sought to resolve? The judiciary would have asked itself another question. Can Kenya truly be a democracy if the people are denied the opportunity to express their sovereign and supreme choice at the ballot box on the basis of elevating technicalities over the overriding objective?
As we celebrate this 58th Madaraka Day, we are reminded that our forefathers worked hard, toiled, shed blood, so that we can have a democratic nation, a nation anchored not on personalities, but on constitutionalism.
And I think the last bit of that remark by Deputy President William Ruto said something like rule of law and not the rule of men. And basically this was a typical jibe from the Deputy President. He knows how to throw those jabs across, and he was basically saying, and the first thing that one would have thought is, did he have some prior access to the speech? And so he saw this very long attack on the judiciary, because this was a solid defense of the judiciary, saying basically, let's respect the Constitution. And then in the prior, in the soundbite that preceded that, what we saw there was the president executing the defense of the BBI. It's something we should have seen with the lawyers in the High Court when this matter was before it. What is your argument? What is your argument for it? There's something he's introduced there that I'm very sure will become a subject of discussion in the days to come. There are two things actually. One is on the issue of devolution, basically the funds that go to the counties. And the second issue is something he's calling ethnic majoritarianism. It sounds to me like the president was making follow-up remarks to what he said during the funeral of the late Mudavadi's mother in Sabatia, when he spoke of the country being dominated by two communities, and it's time for another one. But again, you know, questions will arise on how does BBI actually sort that out? Because BBI, some argue, will actually provide a platform for the big communities, for the majorities to get together, you know, promise the presidency, promise to the prime ministership, the running mates and all this, distribute it across the big five, and we will have true ethnic constitutional majoritarianism through BBI. But that's a debate that will probably come up in the days ahead.
Yeah, can the statement of the burden of choice also be something that creates or puts a target on the back of the judiciary? By saying, I try to sort out matters with BBI, the burden of choice, who will carry the burden of losing 30% of our national budget every 5 years due to the toxic politics that BBI seeks to resolve, in a sense, putting the blame on failed elections or contentious or contested elections that breed violence on the judiciary.
But Yvonne, how much of our past failures can be attributed to the judiciary.
That's and for me,
how much? Yeah.
And for me, that seems to be a case with these statements. If you read it carefully, it's we're trying to fix it, but these are the questions the judiciary should have asked. And you know, in a sense, maybe a few years from now, or when something happens, you say, oh, but you know, the BBI sought to resolve those issues, but the judiciary refused. It's very veiled. That's something that would come up, you know, in the future. And I thought that was, you know, very important to just think about with respect to the implications that might be derived from that statement.
So Francis, let's move now to the BBI, because the new president of the Court of Appeal, Justice Musinga, has during that case management conference, they called it, basically laid out quite a few interesting things about the BBI case going forward, the appeal that has been launched by the various parties. And he said two fundamental things that came out of that thing. One of them, of course, is the idea that we have 7 judges hearing this appeal, and they have been consolidated. And then the fact, which is interesting, that the stay, you know, that all these people wanted, essentially suspended. Now they will hear the full appeal before they can give orders. The IEBC allowed to only conduct all these regular things of by-elections and whatnot, as long as they're not touching BBI. That has serious implications, I should think, with regard to the timelines that we are dealing with when it comes to what could happen to the BBI. I mean, obviously the judges will have to render their decision, but at the end of the day, when you look at the timelines, how the courts work, look at, for example, how long it took to dispense with the High Court case in the first place, how long it took between the time that the hearing ended and the time that we got the judgment. Here we are, 29th of June to 2nd of July. Those are the dates that have been set by the Court of Appeal to hear the cases.
Absolutely. And you see, in this appeal, there is no time limit. It's not like the election petitions where you have a time frame. Within a certain period of time, you must you know, dispense with all these matters. Here, it is what the President of the Court of Appeal told us, together with the other 2 judges during that case management conference, on how much each party will be allocated, how much in terms of submissions they should make.
40 pages.
40 pages. Right. So it gives you an idea that they want this matter expedited, which is a good thing. And it's also a good thing that you want to hear this matter, all the appeals, and deal with them, you know, with finality, because a stay order, if granted, would have been a very good opportunity to drag the case until, you know, God knows when. But dealing with it substantively and concluding it is a good thing. Now, the question that is very fundamental next is, who will be the 7 judges appointed to hear these appeals? Before the President's decision today, the choices were very limited, because before then we had 13 judges in the Court of Appeal. The President himself of the Court of Appeal, Justice Kathurima, who sits in the Court of in the East African Court of Justice, as well as Judicial Training Institute. Then there's the Mohamed Warsame, who is a commissioner in the Judicial Service Commission. Then you remember there are 2 judges who had been appointed by retired Chief Justice Maraga to advise the judiciary on the BBI process, and we all remember the verdict they came up with. So if they were to sit in the same matter revolving about BBI, and some of the issues that the High Court judges ruled on were as well as part of what they advised on, one would ask whether they can sit or not. But be it as it may, 7 judges. And remember, there are many other appeals that are pending. So are you saying first appoint 7 judges here, other matters that are pending be shelved for the time being? Because unless now the 7 judges who have been appointed by the President are sworn in as soon as tomorrow.
They're actually being sworn in tomorrow at 2 p.m.
in the afternoon.
Absolutely, yeah. So then gives you some room to have other judges sitting elsewhere to deal with the appeals that were pending. But at the same time, there's also a question that one needs to ask here now. The 7 judges who have been appointed by the President and will be sworn in tomorrow, are they eligible for inclusion in the 7-judge bench? Of course they are, because they are judges of the Court of Appeal. Unless the bench is decided on before their appointment. So,
or before they even know where their offices are.
Or before they know where their offices are. So there are all manner of things to look at. Then lastly, there are specific timelines to deal with. Yvonne did a good job on an explainer. Some of the timelines that are very specific. If you say the hearings are on 29th to 2nd, so probably the earliest you can get a verdict is on end of July or early August.
Yeah.
Certainly. If the appellants lose, they will go to the Supreme Court. If the respondents who won in the High Court and the judgment is now being contested, if they lose at the Court of Appeal, they will certainly go to the Supreme Court, which also introduces another question, timelines once again. Another month or two. So probably the earliest you can have these matters dealt with finally, either way, is maybe September or thereabout, and that does not stop the opponents of the BBI process from going back to the High Court with another issue or two on the same process and seek to stop it. So look at it this way: the opponents of BBI will find as many reasons as possible to stop the process. On the other hand, the proponents of the process will try as much as they can to make sure that they get a favorable judgment so that they can proceed with the referendum. So there's the legal contest on one hand, and then there's the political contest out there in a referendum.
And right now, so therefore, it is fair to say that the biggest threats to BBI, as it were right now, is not the courts, it's not the petitioners, it's actually time.
And remember, we're 13 months to the general election right now, and by the end of this year, the IEBC will be focusing on, meeting the deadlines that have been set out by the Elections Act, the IEBC Act, preparing for August 2022, and so will the political players and the political parties, because many of them want to put up a serious challenge for 2022, so they'll be putting their affairs in order. Will their attention be divided between a general election and a referendum? Will it be tenable for them to do a referendum or start focusing on, the bigger challenge ahead, which would be the general election?
If things had gone according to plan, Joe and everyone else, the president would have been assenting to the amendments in the next 4 days, according to the planned BBI timelines that were released by the BBI Steering Committee in 2020. He was supposed to have, IEBC is supposed to have a held referendum within 60 days from between 6th of April to June. And then the president was supposed to assent from 7th of June 2021, and that's not what's happening. I just needed to point that out, that if things had gone according to plan, that's where it would have been. But it is Murphy's Law with this BBI.
And one thing that should also be pointed out is the fact that there have been voices, especially from the religious leaders, that have expressed concern about the time left. From the Catholic bishops to the Anglican leadership, and some of the church leaders that spoke during the course of this week, they are all saying, focus on the 9th of August 2022, hold the elections, and then carry on with whatever reforms you want to do thereafter.
One of the major selling points of the BBI process is new constituencies and more resources to the counties. If it passes, it means by 9th of August, we should have gazetted the new constituencies, the 70 of them, 1 year to the general election, although there's a proposal to suspend Article 89.4. Now, I suspect that this could be the next battlefront about creation of new constituencies. Will they apply in 2022 or 2027? Some fundamental questions to ask.
Very, very, very interesting, and considering the fact that after the new constituencies are created, there is the whole thing of, even before, public participation, no, that boundary cannot be there, a whole political...
I don't want to be registered in this constituency.
Plan that.
Yeah. All right, Jamila has a way of...
Let's take this home.
Yes,
and I think tonight you're starting with Kaikai's kicker?
Yes.
Yes, we are.
Let him kick away.
On my kicker tonight, I agree with all those Kenyans who have expressed outrage at the quality and standards of Kisumu's Jomo Kenyatta International Stadium that played host to this year's Madaraka Day celebrations. I am outraged too, and I totally understand all those out there that are equally disappointed. Like most Kenyans, I expected better, especially after the word international was added to the lofty name of the stadium. And I expected better after a senior government official said